Okay. All right, I'll go through our hearing script and we'll get started. This is the February 9th, 2021 session of the Zoning Hearing Examiner docket. My name is David Sturkey. I'm the Zoning Hearing Examiner. I'll be presiding over this hearing. The case before us today is case number ZHUV210017. This hearing is continued from January 26th, 9 a.m. hearing in progress. The purpose of this hearing is to allow applicants and opposing parties to testify and to offer and refute evidence and testimony. This hearing will follow the rules found in the zoning code and the supplemental rules of the zoning hearing examiner. All testimony and evidence that an applicant or any opposing party wishes to offer must be presented at this hearing unless evidence or testimony has been presented in writing or digitally prior to this hearing. Okay, I think we're just going to sort of start from scratch. I'll give the applicant an opportunity to tell me about any of the conversations that have been had. I know that there was an agreement that was submitted prior to this hearing. And so if you guys want to sort of outline that, that would be great. Or any other changes to the design of the project, that would be good. I'll allow Tim and his client to comment on those. And really, I mean, at this point, since it sounds like there is some agreement here, that I'll sort of let each party sort of outline that agreement and how that came about and why that makes this particular project more appropriate. In the event, also allow Doug Owen to weigh in as well. In the event that any party testifies or offers argument in opposition to this application, the applicant will have an opportunity to rebut that testimony, and then I'll allow the applicant to make any closing or final statements. I may limit or exclude any testimony that I deem irrelevant or outside the scope of the application being considered. I may interrupt any speaker to ask questions. I may refuse to consider hearsay testimony. In the event of any technical difficulties, I may have to continue or postpone this hearing, but I'll only do that if I can't troubleshoot the issue on the fly. Okay, let me go ahead and swear everyone in who's not an attorney that intends on testifying today. So if you could take yourself off mute. If you intend on testifying at all, please raise your right hand. I need you to answer out loud. Do you solemnly swear the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes,
I do.
Okay, great. All right, I think that we're ready to get going here. Matt, were you raising your?
No, my iPad caught me. We saw the hand raise and said you raised your hand. So sorry about that.
No, it's fine. It's fine. Okay, so Matt, were you gonna take the lead here on talking about?
I am. I wasn't going to go back into the details that we kind of talked about with the layouts as we did in the first meeting. I was going to go right into the meeting that I had with Mr. Burke, and the adjacent property owner on what we decided we would do there to make sure that they're taken care of and the right things are done. I think, I saw the language that Mr. Burke presented to you that we'd like to get read in and included as part of this hearing. I'm in agreement with that. We had a nice meeting on the site fairly quickly. Thank you to them for making that happen. We walked the site together. We looked at the existing wall. We talked about the issues. We came up with a plan that I think will help both of them. And I'm going to do this. I got caught out and I am off-site in someone else's office. So I'm going to do this by memory. So Tim, please clarify this for me if I mess it up. We are in 100% agreement, but that we agreed that I would, as part of the development and the final record plat of the property, I would donate, I don't know what the right terminology would be, for a 10-foot access easement for them along the boundary of our properties, the full boundary of our properties, so that they could have egress, into the site for any kind of maintenance or repair of the wall. And that we would finalize that on the record plat for them. Okay. We also stated that I would do the boundary surveys to where I could establish where we are and just make sure that there is enough for them to get to the property. And with a little bit more detail of that, I would tell you that that will be agreed on and written into the HOA that will manage the townhome, so that there will be no debate or no negotiation after the fact, that they will have full access and approval to get to it and maintain their wall. to do it. We also said that through the development process, they were going to hire a third-party consultant. They've named it. I'm going to leave it unnamed in case they want to jump back and forth and find a more, I wouldn't want to say I agree to only this person, because I don't. I agree to any professional representation they need on the structural support of the wall, that we would include them in our development of the engineering plans, and they would have an ability to review those and comment to us. The only caveat I would say is I want to make sure that I have the ability to hire my own third party if I disagree with what their rep says. However, I have no intent to hire anyone at this time. It's just I can't be held to a third party consultant that I don't know and have any experience with. That said, I think they'll agree, and I guess I would kind of put it to them now to say, did I get that right? And I mean, fairly close. And are we in the agreement that I think we are, so that we could write that in and go forward for you all?
If I can,
Sure.
yeah, Matt, I think we got fairly close. Let me just fill in a couple of other details that are included in the statement that we submitted yesterday. Part of what we agreed to is that there will be another meeting on the site with the geotechnical engineer that Jim has hired. I think it would be helpful before then for the corners of the site to be marked, so it's clear where the property boundary lines are. I think you've got a pretty good idea where they are. So does Jim, but let's be clear by making sure those are marked. We have the meeting on site. And then after that, as you get ready to submit your building permit applications, our geotech guy gets the opportunity to review those and comment to you and to the city on them. You clearly have the right to have your own engineer do the same and to advise you on what he thinks of what our geotech engineer has had to say. We're pretty optimistic that the professional engineers, if necessary, can reach an agreement so that everybody is protected in this. And what we're requesting is the 3 points that were made in the joint statement we sent to Dave yesterday get included in any conditions that are part of his decision on this.
And I fully agree.
Okay. So if for any reason during these subsequent meetings, there's disagreement, Mr. Walker, are you saying that you're comfortable with this being with agreement on those meetings, or those meetings turn out?
I think ultimately the decision on granting me a building permit would be borne by the city of Cincinnati. And I think what we're both saying is that they would like a representation to say that what I'm doing will not cause problems with their existing structure, with their wall and thus their building, which the city of Cincinnati is going to do a review on any building permit that's given for any property that they've got. Okay. So what they're saying is they just want a representation at that point that says we have reviewed it, we are in agreement with what Mr. Walker is doing, or we're not, and he's a liar and a scoundrel and he's going to rape the earth and it's going to fall down, and we don't want that to happen either. At such time, the city of Cincinnati would either grant me a building permit or tell me what you're doing is going to make their wall fall down and you can't do that. We're just stating that there is a point in the process that they are going to get a chance to review, and that I will provide that to them to review.
And just to be clear, why I don't think this is going to happen, because I've learned something about Matt's reputation, and it's very good as a developer. He's got good architects involved in this. I'm sure he will involve good engineers as well. If we really believed that the city's building permit was issued inappropriately, we would have the right to appeal that. I don't anticipate doing that, but we would have that right.
Yeah, exactly.
Yeah, so I guess how are you suggesting that these 3 terms be written into the conditions of a decision?
Well, let me ask you, State. I think it's probably as easy as this, and Tim will be the ultimate legal guide to this, and I would acquiesce to him. But I believe if we read them aloud as part of the public statement, that gets them as a public record, which should be, I believe, significant enough for them to be able to look back on. Do you agree with that approach, Tim, or do you need, or should it be an actual condition?
In one way or another, I would like to see the acknowledgement of this agreement be included in the written decision.
Okay.
That could be done either by simply repeating it as an agreement that was reached between my client and you, or they could be cited as conditions on the decision. Either way, I think accomplishes what we need for our purposes right now.
Okay.
It's in many ways, it's no different than a good neighbor agreement, which the city with some frequency these days is including in discretionary zoning decisions.
Yeah.
Okay. All right. Doug, as we were talking about this, hopefully you got my email. I noticed you weren't on that email yesterday. Have you had a chance to look at this at all, Doug?
I mean, I just briefly skimmed it over when you sent it a couple minutes ago. So, I haven't had a chance to look at it with any real in-depth assessment. But, based on what I've heard today and what I've seen, I don't think any of this will affect any of the zoning relief that's currently required or will ultimately be issued. So, yeah, I think that this agreement should be fine from a zoning standpoint.
Okay. Thanks. And
can I clarify that access easement, that's just access. There's no actual change to the site plan at all. Is that correct?
Correct. There is no change. It would just allow them to. So the through the conversation when we met, is there going to be 8 homeowners that are there that are part of an HOA? Okay, I need to write that in and put an easement on the record plat so that the 8 people can't vote and change that later. It needs to be a legal easement that gives them access to maintain it. Because to be honest, they really have a wall that they can't maintain correctly from their side. And we have the opportunity, it's the right thing to do. Let's make that, as part of the record plat to help them have access to maintain in the future.
We did the same thing here at our law office. We had 2 buildings very close to one another. The one building actually backs up onto the remainder of our property. When we sold the smaller building at 229 West Court Street, we did mutual maintenance agreements that allowed both owners to get on the other person's property if it was necessary to maintain the wall of their building. And that's all this is doing.
Right.
Doesn't happen all that often, wouldn't happen all that often in this case, but he needs a way to get at his wall.
Right. Yeah. And that was my understanding too. So yeah, zoning, we would not have any issues with that agreement.
All right. Anything else from either Matt or Tim here?
The only thing I would go back to the plan and just state that we have looked at the staff review. We looked at what our relief is, and our we believe that we're asking for a project that the community wants, that the Oakley Council wants, and we're here to answer any detailed questions. But we're pretty excited about this opportunity and being a part of the development in the city.
Okay, Tim, anything else?
No, with the agreement that we reached, we have no objections to the zoning relief being granted.
Okay. So I am going to approve the relief, and I will include the agreement in the decision. I need to, take some time to type that up and formalize it in a written decision. That generally takes about 2 weeks. I'll try and get it out as quickly as I can. As soon as I finish it, I'll share it with everyone who's in the hearing today. So you all have a copy of it really just moments after it's complete. And then Matt, you can start working with Doug on the necessary permitting from there and completing the terms of the agreement that you've reached with Mr. Burke and his client.
Great. Thank you all very much. It's been a pleasure to work with all of you. So thank you all.
Okay. Thank you all for your time and testimony. Hope
Thank
you all have a
you.
wonderful day.
Thanks, you too.